How can specific lease phrasing win or lose a landlord court case? Imagine a court case where a few words in a lease decide whether a landlord wins or loses. The way lease terms are written can make all the difference in the outcome. Courts look closely at the exact language used in lease agreements because they follow the four corners rule. This means they interpret the lease based only on what's written inside the document, not what the parties might have intended outside of it. If the lease language is clear and complete, courts tend to enforce it as written. But if the wording is vague or contradictory, landlords could face unfavorable rulings. For example, if a lease does not clearly specify who is responsible for repairs, courts might interpret that the tenant must handle all maintenance. Or, if a lease says nothing about penalties for late rent payments, the landlord might struggle to enforce late fees. Clarity and completeness are key. Courts prefer leases that explicitly state the rights and duties of both sides. If a lease is missing details about how to handle breaches or remedies, courts might side with tenants or refuse to uphold certain claims. Legal compliance is another big factor. Some lease clauses can be invalid if they break laws or go against public policy. For instance, clauses that try to waive a tenant's right to a safe and livable home are often invalid. Landlords should avoid including illegal or overly broad clauses because courts can strike them down, weakening the landlord's position. Using phrases like subject to applicable law can be tricky. While these phrases acknowledge legal duties, they can also create confusion if the lease doesn't clearly spell out responsibilities. Courts recognize that landlords have legal obligations regardless of what the lease says, but unclear language can make enforcement difficult. Acceptance of rent after a breach is another area where wording matters. If a landlord accepts rent after a tenant breaches a lease, it might be seen as waiving the right to claim that breach later. But if the lease states that rent is accepted only with notice of non-renewal or breach, the landlord can protect their remedies. Precise language about rent acceptance and notices helps keep rights intact. Specific clauses about remedies also matter. Well-drafted provisions like alternative rent structures or co-tenancy clauses can stand up in court if they are phrased as performance options rather than penalties. Courts scrutinize whether these remedies are enforceable or considered penalties, so careful wording is essential. In practice, landlords and property managers should draft leases with clear, precise language that covers all key obligations and rights. Avoid illegal clauses that could be invalidated. Clearly define maintenance responsibilities for both sides to prevent disputes. Use specific notice and rent acceptance language to protect remedies if breaches happen. Consulting legal experts ensures lease language aligns with current laws and court interpretations. In short, the words used in lease agreements can determine whether a landlord wins or loses a court case. Clear, lawful, and thorough lease language strengthens a landlord's position, while vague or illegal phrasing can lead to losing. Proper drafting and legal review are essential to protect your interests in any dispute.